Hello, good morning, viewers. As well aware that I am Dr. Jetting Yellosa. I am running a YouTube channel called Law Speeches, in which I am posting my lectures on various subjects of law, also the world affairs. And today we discuss another important topic, that is the governors. The governor post and its relevancy, constitutional background, and also the recent decisions with regard to the functioning of governors. You know, the Constitution of India provides us basically three kinds of governance. One is at the union level, that is the central government. The state level, we have the state governments, and the local level, we have the municipal corporations, municipalities, nagar panchayats, gram panchayats, cantonment boards, etc. and etc. So we are not going to discuss those. Now today we are focusing upon the governor. The state government is a important aspect in the administration, and this sort of arrangement is made by the Britishers when they are ruling us, and that was continued even after we got liberated from the Britishers, and we the constitution also, when it came to force from the 26th of January 1950s. And there is a talk also going on that the post of governor is became a political appointment. So we will discuss all those things in later. So the Constitution of India provides that under the Article 154, there should be office of the governor. The governor is appointed by the union government on the recommendations of the Prime Minister, and his warrant of appointment is given by the President of India under the Article 155 of the Constitution of India is concerned. So the terms of office of governor is appointed for the term of the 5 years till a successor will come and join as the governor, which is stipulated under the Article 156 of the Constitution of India. Then the qualifications of the governor is concerned. Simply, he should be a citizen of India. He should be completed the age of 35 years, and he should not be a idiotic, a paranoid, insolvent. So these are all things are there to the other constitutional positions that also been attached to this as a qualification for to become a governor. Then oath of office and secrecy of the governor is concerned. He will be administered by the Chief Justice of the State Judiciary, or the senior most judge of the State Judiciary, that has been stated under the Article 159 of the Constitution of India. Then now we have to discuss what are the powers of the governor. So the governor enjoys the same powers that have been enjoyed by the President of India. Those powers include: number one is executive powers, is the executive head to the state government, and all the activities of the state government will be handled in the name of the governor of the state. Then he also has the military powers. He is considered as the fountain of the military power in the state is concerned, and he has that power is conferred. Then all the state government constitutional appointments are being issued in the name of the governor. Like any boards are there, and like public service commissions or the advocate general offices, the appointments are made by the governor only on the recommendations of the state government. Then the governor also enjoys the coordination powers. He addresses this joint session of the state legislature and the council, and he laid down the work the state government want to do, and he has also has the responsibility of the legislative power. That means under Article 213, if any important legislation has to be made of, and the legislature is not in meeting, then ordinance making power is conferred upon the governor under the Article 216 of the 213 of the Constitution of India. Then he also has the legislative powers. So whatever enactments passed by the legislatures or councils has to be ratified, assented by the governor. Then only it becomes the law. Till then, it cannot be called as a law. Then he also has the power of previous sanctioning the bills. He can sanction certain bills that requires the is accent, otherwise those cannot be accepted. Then he has a nominated powers, so he can nominate the members into the legislative assembly under the governor quota. That power also been there in the hands of the governor. Then there is another power is that is the rule making power. The governors place very rules, frames the rules, and they have the power to make the rules. That is there under Article 166, clause number 2 of the Constitution of India. Then another important power which is vested in the hands of the governor is the financial powers. So the budget to be passed in the legislative assembly, but it has to got the approval from the governor. So, in addition to that, the governor has also conferred the same power that of the President of India enjoys. That is under Article 72 of the Constitution of India. That is a pardoning power. That power is there in the hands of the governor under the Article 213 of the Constitution of India. If any convicted person can make an appeal for lessening of the punishment or removal of the punishment, cancellation of the punishment, the governor has the right to cancel. But he has to take the consult the state government. Without consultation, he cannot do it. But nowadays, what is happening that the governor position became a rotundity, a political shelter house to the ruling elites. And we have seen the confrontation between the governors and the in between the state elected representatives, state government. We have seen such incidents in past as well as in present. That is, you take the example Delhi government, the Delhi governor. There is a confrontation. Then West Bengal, the confrontation. Then recently in Telangana also we have seen the confrontation between the governor and the state, and in Kerala, in Tamil Nadu, in many places where the central government party is not ruling, in the different parties ruling in the states, the confrontation is becoming the very big issue. And we have seen number of cases. People are filing, governments are filing cases against whether the governors has the power to withhold the bills passed by the legislature. So such have seen in Telangana recently, and we have seen in the Kerala also. The Supreme Court has categorically stated that no, the governors has no right to withhold such bills passed by the state legislative assemblies or councils. And in recently, the Supreme Court has given number of important decisions which pertains to the governors under different judgments. Those are, I am quoting here, Kushal Kishore versus State of Uttar Pradesh, 2023 judgment. So in this case, the Supreme Court has stated that the public dignitaries has to maintain certain decorum. So the governor position is a decorative position, and he should not disparage the state governments. So he has being the head of the government, he should has to respect the state government. And in way back in 2006 also we have the very famous case that is the Rameshwar Prasad versus Union of India 2006. In that case also, when the governors they are abusing their power in the state of Bihar, then the matter came to the Supreme Court. Supreme Court has stated that, I am quoting here, that motivated and the whimsical conduct of the governor is amenable to judicial review. So they comes under the judicial review. The governors are not far away from the judicial review. Their actions are not far away from the judicial review. Though Article 361 provides certain immunities to the governor, but immunities they have been enjoined as per the wordings of the Article 361 of the Constitution of India. It is not a full immunities they have that has been categorically stated by the Supreme Court in this decision. And even because in the Sarkaria Commission recommendations also stated that we have to reform the appointment of governors because political people have been appointed. What is happening? There is a confrontation between the state governments and the governors, and the governors are appointed by the central government. They are acting on terms and conditions of the central government as their agents. That is stalling the progress of the state. And even in Justice Punchi Commission report of 2010 also stated that, I am quoting here, to be able to discharge the constitutional obligations fairly and impartially, the governor should not be burdened with the positions and powers which are not envisaged by the Constitution. It said that conferring statutory power on the governors by posting them as a chancellors of the universities will have the potential to expose Rajbhavan to the controversies or public criticism. So they should act within in a fair and in a good manner. So they should not confront with the government, with the state governments. You know, in the state governments, the universities, state universities, governor act as a vice chancellor. So he has to see that he should discharge his positions in a fair and in a fixable manner. So it is a time that we have to think over to reform the position of the governor. Even at the time of appointment itself, we have to see that not only the appointment is to be made by the Prime Minister, consulting with the Prime Minister, but a opposition leader also been consulted. And the position of the governor is not a position where ungrounded elements or the political elements should be occupy that position. So when the Constitution clearly states center-state relations, there should be a good center-state relation should be there. And the governors always meddling with the affairs of the state, that may not augur well, and we are acting against to the position of the principles which have been enshrined in the Constitution of India. So it is a time to reform. Otherwise, in years to come, the confrontations may get more and more in violent manner. And the central government should appoint very academicians, good administrators, and public service oriented persons as a governor, not a political people. And they have causing a kind of strain in relations with the center and the state, because the governor's position is a very pivotal position which Constitution provides. Even if the Article 356 is imposed, the governor gets the full power to rule the state. So in such is the important positions, the central government should rethink and to make a concrete amendments to protect the Constitution of India. Thank you for patiently hearing my lecture. Thank you, Ananda.